This is State of Ohio versus Rodney Stutzman, 19AP0050. Thank you. Whenever you're ready.
For the record, may it please the court, I am John Williams, Special Prosecuting Attorney for Wayne County, appearing on behalf of the state of Ohio. Let me say at the outset, we realize that in order to prevail in this case, we must establish that the trial court abused its discretion. That means we must establish the trial court's decision was unreasonable, arbitrary, or unconscionable. We do not intend to imply that the trial court's decision was unconscionable. We do not believe there was any malice in the court's decision. However, a capital case is one that is one of the most difficult cases for any judge to preside over. Repeated findings of incompetence to stand trial create a potential for short-circuiting a fair adjudication of the case by an impartial jury. And for that reason, the trial court's motive should be examined. First, was the trial court arbitrary?
Mr. Williams,
Yes.
Can I interrupt just for a second? Do you want to reserve any rebuttal time?
Yes, if I could reserve 5 minutes in case the defense presents a case.
And obviously, if they don't end up coming in, I'll just let you go with your whole 15. All right, thank you. Go ahead.
Thank you very much. Was the trial court's decision arbitrary? Well, the trial court believed the original testimony of Dr. Ashkenazi, the sole defense expert. That alone is not arbitrary. However, with each subsequent hearing, the prosecution presented more and more evidence to the contrary. More witnesses, all with extensive qualifications or many years of experience, more direct experience with Mr. Stutzman, and more objective facts, testing, and observations. The defense expert largely repeated the same narrative as before. Nevertheless, the trial court believed the defense expert and was not dissuaded by anything that the prosecution presented. When we view this process from the beginning, it becomes clear that there was no evidence that the prosecution could introduce which would change the belief of the trial court that the defense expert was right the last time and she must be right this time too. That is arbitrary. Was the trial court's decision unreasonable? The trial court was impressed by the qualifications of Dr. Ashkenazi, the defense expert, particularly her expertise in the area of malingering. The trial court also relied on Dr. Ashkenazi's opinion that Mr. Stutzman's condition improved with medication. Those findings, when considered together, are at odds with the greater weight of the evidence. While Dr. Ashkenazi may have expertise in her field, she is not qualified to prescribe medication. In fact, at an earlier hearing in 2013, Dr. Ashkenazi testified that Mr. Stutzman received a powerful antipsychotic on a daily basis, but later she retracted that statement, admitting that the drug was only given as needed and had only been given a few times. Dr. Smith testified at the same hearing that the drug was given only for emergency agitation, the same as it is often administered in hospital emergency rooms. At the 2018 hearing, Dr. Smith and Sainer, both of whom are qualified to prescribe medication, testified that psychotropic drugs were given to Mr. Stutzman only for his anger and irritability, not because he was psychotic. For the trial court to discount the testimony of Dr. Smith and Sainer on a matter which they are clearly qualified to testify, and to find greater credibility in the testimony of Dr. Ashkenazi regarding a matter which she lacked the requisite professional qualifications, was indeed unreasonable.
Mr. Williams, could I interrupt you just for a second? Because I was a little confused. I understood the evidence that was presented, or I think I did, with the Haldol, that's administered when somebody's actively psychotic and acting out and have to do something immediately. But correct. I was a little confused when you said that the other medications were only prescribed for anger and irritability, more like his personality disorders than any psychosis. But at the same rate, aren't the medicines that were prescribed to him still used for psychotic patients as well as for people that have been diagnosed with a psychosis?
Yes, I believe there. Seroquel is an antipsychotic. Effexor is an antidepressant. Both of those were prescribed for him, so they could be prescribed for a psychotic person, but that was not the reason that the doctors who were qualified to prescribe prescribed them.
Now, whenever we read the transcript, are we going to find that they testified as to like dosages and certain dosages, obviously with medications are used to treat, you can treat different conditions with different dosage, you know what I'm trying to say, doses. There we go. You can treat different conditions with different doses. So did they talk about how many milligrams he was getting or so forth?
I don't recall. They may have, but I cannot say that with certainty.
Okay. Okay, thank you. I'm sorry.
That's all right. The trial court also found that Dr. Ashkenazi performed objective testing on Mr. Stutzman, while the only prosecution witness to do so was Dr. Tilley. The trial court then found that Drs. Ashkenazi and Tilley merely interpreted the results differently, and that Dr. Ashkenazi's interpretation was more credible. However, the record demonstrates that Dr. Ashkenazi's interpretation of that objective testing was really quite subjective. Drs. Ashkenazi and Tilley both testified that the SIRS test, structured interview of reported symptoms, was a highly respected objective test for malingering. However, Dr. Ashkenazi had not administered that test since 2011, and she subjectively invalidated the test results, which showed Mr. Stutzman to be in the probable malingering range because she felt that he was actively psychotic. Dr. Tilley administered the same test before the most recent hearing and also found probable malingering. However, Dr. Tilley clarified that the test should only be invalidated when the subject is grossly psychotic, so disorganized as to be incoherent, and that a person being actively psychotic is exactly what the test is designed to determine. Under those circumstances, the trial court's decision that Dr. Ashkenazi's opinion was more credible is clearly unreasonable. Finally, the court relied upon Mr. Stutzman's biological mother's history of schizophrenia. At the most recent hearing in 2018, Dr. Ashkenazi never mentioned the mental health history of Mr. Stutzman's biological mother. However, in 2013, she did mention that Mr. Stutzman's mother was a chronic schizophrenic and that there could be up to a 50% chance that he too would be schizophrenic. Dr. Ashkenazi never offered any personal research or peer-reviewed studies to support that statement. Conversely, at the most recent hearing, Mr. Stutzman's counsel cross-examined Dr. Tilley on the same subject. Dr. Tilley believed there was only a 10 to 25% chance that Mr. Stutzman would inherit his mother's schizophrenia. In the absence of any scientific statistical evidence, how could the trial court assume that the 5-year-old opinion of Dr. Ashkenazi was automatically more credible than the current opinion of Dr. Tilley, neither of whom showed any evidence or peer-reviewed studies that say this is the percentage likelihood that a person will inherit schizophrenia from a person, from a mother, a father, a person on the same level of
Mr. Williams, I may not ask this correctly, so I apologize in advance. But did anybody get into the issue, and of course we'll read it in the transcript, but did anybody get into the issue of just what you're talking about, and that is the test that the defense expert gave him was in 2011, which at this point now in 2020 is 9 years old. But did she indicate why that was still valid? Because one of the concerns I have is how often should you reevaluate somebody for malingering? Couldn't that change over time, or did anybody get into whether it could or could not? Was it, in other words, was it static, or you know, why did anybody talk about why she did not present any other test?
That was never really addressed by Mr. Stutzman's counsel. That original test, I mean, I suppose that we consider it a bit suspicious. This so-called gold standard test was administered in 2011. She invalidated the results and never retested on that basis. And under those circumstances, we would have concern that because her original testing showed probable malingering and she invalidated those results, that maybe she didn't want to introduce that test again. Dr. Tilley did it prior to the 2018 hearing. He made the findings of probable malingering based on the test results and indicated that it shouldn't be invalidated unless a person is grossly psychotic. In other words, you can't get anything coherent out of them. But if they are actively psychotic, that is the whole reason that the test is designed.
Mr. Williams, I'm going to ask you to pause for a minute. You're into your rebuttal. It is my understanding that Mr. Doughton is trying to join us. So if we'll just let me check with Kit
Okay.
and see what's going on here. I'm not quite sure how to do that, but I don't want you to use up your full 15 minutes. I want to leave you your rebuttal time, assuming he joins us here. Mr. Williams has given his argument.
Okay.
I'm sorry, I didn't have the benefit of hearing it. He has reserved 5 minutes for rebuttal and made sure we stopped him when I heard that you were in fact going to join us. So you will have your full 15 minutes to present your argument, and we are, as I had said earlier, we have read the briefs and we're ready to hear you when you're ready to start.
Well, thank you very much, and I'm sorry for the confusion, but I guess it happens.
It does.
I guess my point that I'd like to make is that you know, the brief, everything I want to argue is in the brief, but I would like to highlight a couple of things for the court. You know, first, again, the first two hearings, which Dr. Ashkenazi testified, Rodney was found competent, and the state did not appeal, which is fine. The third one they did, and this court remanded it, and they remanded it because there wasn't enough of a record to make an assessment. We did not appeal that to the Supreme Court of Ohio because, in retrospect, the court was right. You know, we agreed there should be more. Normally, I'm on the other side of these competency hearings where, you know, we want the judge to say more if they can. And so we didn't appeal and went back. On remand, the judge went through and followed this court's dictates. He explained why he made the decisions that he did. He found that Dr. Ashkenazi was the judge who had done the independent testing. He had found that he believed or found credible her testimony that there wasn't malingering, as said by the witnesses for the state, prior to or improving or increasing near the hearing. In fact, he relied upon a finding where she had indicated that he made good effort. He in fact improved in some areas, and the judge cited the fact that Rodney had improved in some areas with medication, which he found contrary to a fact that he wasn't giving effort or he was malingering. The point is, this isn't a weight of the evidence argument. You know, again, usually I'm on the other side. The question is, is there enough on the record so that the judge's finding as to weight, there was enough there to base it on? You know, the Court of Appeals may disagree, the prosecutor may disagree, but that's what the judge does. The judge is in the courtroom, he's observed the person in person, he's been able to observe this person over a period of times, He's been able to review all the records, including not just from this hearing, but from all the hearing. And so that by going through and defining, here's why I gave her the weight. She did objective testing. You know,
Counsel, could I stop you for a minute? I know we only have 15 minutes, and I have a couple questions that I just wanted to make sure I got in.
Sure.
My understanding was the initial objective testing, as you refer to, was conducted in 2011. Is that correct?
Yes.
Okay. And did anyone talk about why there was no retesting, that she didn't do any retesting in the last 9 years?
Well, she did retesting in other matters. You know what?
But I'm talking about with the malingering.
Not the specific, not the specific ones, but she had found and I don't remember the exact wording, obviously, but she had found that his actions were consistent. There was nothing that she saw in what he did or she saw in the record that was inconsistent with those records. And she did administer other records or other testing updated.
Counsel, let me just, and maybe I'm misunderstanding something, so maybe you can
Sure.
correct me and unconfuse me, enlighten me. But whenever I hear a test is invalidated, the first thing I think of is it's not valid. That's what invalidate means. So how can you use it after you have invalidated it?
Well, she testified as to that. She explained the fact that she thought he was actively psychotic at the time that he took it, in retrospect. And so, if anything, is she, I guess, I'm going to parse my words correctly, while saying that she had questions as to that testing, the fact that he was actively psychotic was consistent with her diagnosis in general, so that she didn't see the need to retest at that point.
Okay, but I guess I'm confused because I thought the testimony from everybody was that that test was invalidated because he was actively psychotic.
Right, that's correct.
So if it's invalidated, how do we use that test for anything?
Well, I think, I guess she wasn't relying on that test in and of itself. You know, there were other tests given. There were a number of tests given. There were a number of observations that she made. And in fact, the test was a backdrop to show, I mean, it's ironic. She even testified that for instance, his IQ was very low. And she said, I don't think that's valid. In other words, I don't think he's an Atkins test because when you're psychotic and you're taking, testing, it hurts you downward so that, there isn't an Atkins issue based on her testimony. The testing, if she's right and he was actively psychotic at the time, that's something that the state is arguing he wasn't psychotic. So we have this dichotomy. You can't have it both ways. If he's psychotic, that's consistent with being incompetent in the diagnosis. If he wasn't, then it's valid. Her reason why she said she doubted his validity was because he was actively psychotic, which the state said is not accurate, or that's what they're arguing.
And that's what I'm trying to figure out with both sides. Like you said, you can't use it both ways, I guess is what my concern is.
Correct.
And the judge obviously took, put a lot of emphasis on the objective testing that she did, but
it wasn't just one test.
Yeah, but I'm just talking about the malingering though, because the malingering is what we're all talking about here, right?
Yes, but then the judge also cited, well, not just the malingering, because Dr. Ashkenazi testified, you can malinger and be incompetent. You can be incompetent and be manipulative. And she goes in to explain that even somebody's incompetent, but the difference is what you're malingering or what you're being manipulative about is to get things like a nicer room, more TV time, better food. It wasn't dealing with the case itself. And so that her diagnosis of malingering, which I'm sure to the court's well from her CFE is her specialty, wasn't based on that test alone or this type. It was all through. And the judge cited other things in the testing. The judge said, look, it looks, he was improving. He was improving with medication is his view of the records. So
but let But let me ask you this. I just want to understand. I'm sorry. I don't mean to keep emphasizing this test, but it's very critical for me to understand what's going on. So I understand what your argument is, that the court relied on other factors other than the objective test that was given in 2011. But I guess the court still did rely on that objective test. And I'm wondering, how do you rely on something that the person that gave it, that the doctor that gave it, it says is invalidated?
Well, except for I'm not sure that his order, you may be reading it differently, and I'm not saying wrongly, because he talks about independent testing. I don't think he relied upon that particular test, or this particular test is the reason that I'm finding him incompetent. You know, I don't think that that's the nature of what he was saying.
Okay.
There were a variety of factors. If I would agree with the court, if he would have said, you know, for this 2011 test is the sole reason that I'm doing this, and it turns out that test was invalid, well, then I would agree with the court. But it wasn't just that, and I didn't think, in his opinion, he specified a heavy reliance or undue reliance. I thought he made a general reference to the independent testing, much of which was agreed was valid. There was a difference in experts as to how to read the testing, but they had found that, you know, independent tests were valid.
Thank you.
So I guess that where we are, is that, again, the question is did the judge say enough? Again, as we said, we agreed with the court the last time in standing back that there's got to be more for both sides, and we agreed with the court, which is why we didn't appeal it. But now, with the record, with all the reasons, if the court were to say, well, you know, his finding is invalid because one of the factors that he relied to competent, it's not clear. Well, I mean, if the court wants to do that, that's fine, obviously. But I think that there's enough, even independent of that, to uphold what his decision is. And again, it's in all these cases. I was looking for a case, and again, normally I'm on the other side of these. I was looking for a case where to find where a reviewing court actually substituted its judgment for that of the trial judge on a competency issue. I really couldn't find one. The prosecutor cited White in a case where the Supreme Court did, but that was a IQ matter. That was an Atkins issue where two experts, there was no dispute between the two, and the trial court ignored both experts and relied upon a lay witness's views. That's different than this case. This case, we have experts who differ, both qualified, and there was a disagreement on approaches. One, the state relied heavily upon their experience, and what they saw was typical or normal, which they're allowed to do. And the defense expert relied, misinterpreted it differently, but also relied on more testing, and the judge decided which one he found was more credible on this point. So it's a slippery slope to try to substitute under the circumstances, but I suppose if the court wants to remand it back to clarify what it relied upon, I mean, that's fine. I think there's enough there, but and I should say this is adversarial, but it really isn't. I would love for Mr. Stutzman to be competent. I would love to be able to try to work something out in this case. He's severely mentally ill, regardless of the situation. So this isn't a matter that, again, if we were trying to extend things, we would have appealed the court's decision the first time. It's a capital case. We can go to the Supreme Court, but we didn't do that. So, we would love for him to be competent, but as a lawyer, if I don't think, and this court, as much or more than anybody, understands how complicated issues are in a capital case, that before we can go forward and try to negotiate out some sort of resolution, we have to ensure that he's competent, and the evidence before us is such that I think it does establish by preponderance that he's incompetent. And other than that, I would rest on the brief.
All right. Thank you. Any of my colleagues have any questions? or Mr. Dutton?
No, thank you.
All right. Righty. And Mr. Williams, you have your full 5 minutes then.
Thank you, Your Honor. Counsel described a sufficiency of the evidence standard for what is necessary for the court to establish. But the one thing that I think we need to look at here, we're looking at this last hearing, and then we're looking at a history of hearings. All along, it has been Mr. Stutzman who had borne the burden of establishing the incompetency to stand trial by a preponderance of the evidence. And that standard was the same last hearing as the first hearing. I think, though, that we also have to look historically when we are judging whether or not the court was abusing its discretion by what's happened in the past. When Dr. Ashkenazi was believed the first time around, how could we say that the court was being arbitrary with that? However, as it goes on, as more witnesses are introduced, as the evidence piles up contrary to the testimony of what Dr. Ashkenazi opined, I think that needs to be examined. At the last hearing, there were 5 different witnesses, 2 licensed and experienced psychiatrists, a forensic psychologist, a licensed independent social worker, and a registered nurse, both with about 30 years of experience. When we're talking that type of experience and their direct contact with Mr. Stutzman, I think all that needs to be considered in light of what we've seen before. As to what counsel indicated about the SIRS test, it remains the fact that that is the single test that was considered the gold standard, and I believe both of them agreed on that, for malingering. And Dr. Ashkenazi conducted that test only in 2011. And I believe the record will show that they both agreed on the scoring, and they agreed on the scoring of the test that Dr. Tilley did before the hearing in 2018. That they may have interpreted differently, but there was no faulting with how he scored the test, that he scored it accurately, and that there is an objective scoring system for that test, and he found probable malingering. The only difference between the 2 testing by Dr. Ashkenazi in 2011 and Dr. Tilley in 2018, or before 2018, was that Dr. Ashkenazi, invalidated the test score, said he was actively psychotic. Now, as we mentioned before, the standard is grossly psychotic and largely unable to test because of their psychosis, and that actively psychotic is what the test is supposed to score for. But the fact remains that both of them had the same findings. She decided to invalidate those findings, Dr. Ashkenazi did, but when she was questioned about Dr. Tilley's testing in 2018, she agreed that the test was scored pursuant to the standards used for scoring that test, and that she had not reconducted the test. She couldn't say in her circumstances, other than her more recent observations of the defendant, that when that test was conducted that he was grossly psychotic. So we believe, actually, in terms of recency of the testing, that Dr. Tilley's was by far more credible. And unless the court has additional questions, we have nothing further to offer.
Anything?
No, thank you.
All right, gentlemen, thank you both for your arguments. We will take the matter under advisement and issue a written decision in due course, which will be mailed to both sides, posted on our website and on that of the Supreme Court. Everybody have a good day and stay safe.
Thank you very much.
Thank you all.
I'll give you guys a phone call.
Okay, sounds good.
Thanks.